Hello, and thank you for joining us for an updated version of part 1 of our countdown to the UPC webinar series, which is about the opt-out and transitional period of the UPC. My name is Paul England from Taylor Wessing, London, and I'm joined in Munich by my colleague Verena Bertram. Now, just a couple of things before we start. On your screen on the right-hand side, there should be a Q&A box that you can use to send questions by email. If you do that, please feel free to do that, and we will get back to you with answers as soon as possible after the end of the webinar. And the other thing is, just as we finish, please stay for the pop-up survey at the end, which should appear on your screens just after we close. Okay, so this webinar is an update because there have been a number of developments since our original webinar on this subject, broadcast on the 24th of June 2014. There are two developments in particular, one general and one specific. The general development is that the rules of procedure of the UPC are now, of course, essentially agreed, whereas the first version of this webinar was based on the 16th draft. The agreed draft has since clarified or altered a number of important aspects of the UPC opt-out. The more specific development is that a protocol to the UPC on provisional application was signed on the 1st of October 2015, and as Verena will explain a little later, this protocol determines when opt-outs can be registered. There are also some wider developments to report by way of an update on the progress of the UPC. Firstly, it's been reported that Bulgaria is to become the 10th contracting state to ratify the UPC agreement within a matter of days. This means that the ratification of only 3 further countries is now needed, which must include the UK and Germany. Secondly, the process of recruiting judges to the UPC is about to start, although the details of how many judges from each of the contracting states and whether they will be required full-time or part-time still remains unknown, at least in public. Thirdly, a code of conduct for practitioners of the court is expected to be signed in May. And then lastly, it's now accepted that the January 2017 start date for the court, which was last proposed by the preparatory committee, is no longer going to be possible. No new date is being suggested, but it's probably unrealistic to think that the court will begin before early to mid-2017, and certainly not before March 2017, probably more likely in the middle of the year. So, let's turn to the main subject area of this webinar, the UPC opt-out and the transitional period, both of which issues are interconnected, as you'll see. To understand opt-out and the transitional period, it's first necessary to look at the big picture to see how the UPC fits into the European patent system as a whole. This is because the UPC will not exist in isolation, but in side by side with the existing system of national courts of the European countries. In fact, when the UPC system is operational, there will actually be essentially about 3 kinds of national courts, depending on the relationship of the country concerned with the UPC and the European Union. And these are what are shown schematically in the slide. First of all, the national courts of the 25 EU member states that are contracted to the UPC, or the contracting member states, are represented schematically in the slide by just 3 dark blue boxes. The courts of the 3 EU member states that have not signed the UPC, that is Spain, Poland and Croatia, represented schematically by the box with a dotted outline. And thirdly, national courts of the countries that are signatories to the European Patent Convention, which cannot join the UPC because they are not EU member states, are just represented here schematically by 1 white box. Now, unlike the other courts shown, The third type of court, the non-EU court, cannot refer matters to the Court of Justice, which is the black box at the top, but all courts to a greater or lesser extent take notice of decisions of the Boards of Appeal of the European Patent Office, which is the grey box at the bottom. For simplicity, the UPC Court of Appeal and the National Appeal Courts are not shown in this slide. Now, the UPC itself, although most easily thought of as a separate jurisdiction of its own, is actually a court of each and every contracting member state simultaneously. This is represented in this slide now by a box in black outline, which I've just added, which overlays the courts of the contracting member states. And the important point from this is that opt-out and the transitional period are concerned with the interrelationship between the UPC, as shown by the black outline box, and the contracting member states, shown by the blue boxes. All the subsequent slides that we will look at in this webinar are concerned with the relationship between these two types of court. So let's begin looking at those slides. Now, when the UPC comes into force, it will also be possible to request that newly granted European patents become European patents having unitary effect, which are referred to, of course, as unitary patents. This means there will be three types of patent available in Europe under the new system. These are unitary patents, European patents, sometimes now being called classical patents, and national patents. The question then is, which of these patents can be litigated in which type of court in the new system? The answer is that disputes concerning national patents will continue to be heard only in the national courts. This will not change in the new system. In contrast, unitary patents will only be actionable in the UPC as regards matters within the UPC's exclusive competence. This includes the key areas of revocation, enforcement, including injunctions, and non-infringement declarations. These two jurisdictions are represented schematically in this slide, where the arrow at the top of the figure illustrates the UPC jurisdiction and shows that all unitary patent actions are being filed in that UPC jurisdiction over time, moving towards the right-hand side. The grey and broken outline arrow at the bottom of the slide shows that all national patent actions are being filed exclusively in the national courts over time. Because national patents and unitary patents are essentially locked in to their respective jurisdictions in this way, they are unaffected by the opt-out rules and the transitional period. Instead, it's the jurisdiction which European patent disputes are heard that is determined by the rules on opt-out and the transitional period. And the rest of the discussion in this webinar therefore concerns European patents only. So let's look at the transitional period and opt-out as it is in the UPC agreement. All European patents will eventually be subject to the exclusive jurisdiction of the UPC. However, there's a period of adjustment called the transitional period, which will operate first. During this period, patentees have some element of control over whether their patents are subject to potential actions in the UPC. The transitional period is governed by Article 83 of the UPC agreement, and the relevant parts of that article are shown. Article 83.1, starting at the top, provides that the transitional period will initially last for 7 years. During this period, revocation and infringement actions concerning a European patent can be filed in the UPC against the whole bundle, or the national court against national designations individually. In other words, there is a choice. Article 83, paragraph 3, then goes on to say that during those 7 years, a European patent, and only a European patent, can be opted out of the UP system entirely. This is subject to an important limitation, which I shall come to. in which an action concerning that patent has already been lodged in the UPC. Finally, at the bottom in Article 83(4, the ability to withdraw the opt-out is provided. This too has a limitation, where an action has been lodged in a national court. Otherwise, the withdrawal of an opt-out is possible at any time, including after the 7-year transitional period. We can see what this article does by going back to our schematic picture. So this slide that you can now see develops a picture of the jurisdiction in which actions can be lodged over time by adding a European patent stream. As I said, during the 7-year transitional period, European patents can be litigated in either the UPC forum, the top dark blue arrow now, or individually in the national courts of their designation, which is shown by the bottom dark blue arrow. However, once the transitional period has expired, which is shown by the vertical dotted line in the middle of the slide, all disputes about matters within the UPC's exclusive competence concerning European patents must be filed in the UPC and the UPC only, although actions already started in the national court must continue in the national court. So this is shown by the blue arrow, which leads up from the national jurisdiction to the UPC jurisdiction at the end of the transitional period. The effect of opt-out is to remove the choice of the UPC as a jurisdiction for European patents during the transitional period and for the rest of the life of the patent, together with any SPC based on it. And that's now shown in this slide. In the slide, the light blue arrow shows the effect of the opt-out on the jurisdiction in which a European patent must be litigated. On the left-hand side of the figure, the light blue arrow descends from the UPC jurisdiction down to the national court jurisdiction, indicated that the opted-out patent can now only be litigated in the national court of its designation. In the slide, the opt-out is shown schematically as taking place halfway through the transitional period, but it could be exercised at any time from the first day of the court's operation, or indeed the provisional protocol period, which you will hear about, up until the expiry of the transitional period. However, after expiry of the transitional period, the opportunity to opt out a European patent is lost. So this next slide now illustrates the effect of withdrawal of the opt-out. Withdrawal takes the European patent concerned out of the exclusive jurisdiction of the national court of its designation and back within the dual competence of the UPC and national courts, that is, if it's withdrawn prior to the expiry of the transitional period, or it brings it back within the exclusive competence of the UPC if it's withdrawn after the end of the transitional period. As I said above, subject to one limitation, an opt-out can be withdrawn at any time, that is, before or after the transitional period expires, and at any time during the life of the patent or that of an SPC based on it. So let's look more closely at the limitations on opt-out and withdrawal of opt-out that I mentioned. We've seen that during the 7-year transitional period, the proprietor or applicant for a European patent may opt out that patent from the exclusive competence of the UPC. However, if an action relating to the patent has already been filed in the UPC, the opt-out is barred. This bar is permanent. It survives the conclusion of the litigation on that patent in the UPC. The rules of procedure are not specific about the type of action that needs to be filed in the UPC to have this effect. Consequently, if a party wishes to opt out a patent, they need to consider doing so early if they wish to avoid the possibility of being locked in to the UPC jurisdiction. Like opt-out, there is also an important restriction on the ability to exercise the withdrawal of an opt-out. If a European patent is already the subject of litigation in a national court, the withdrawal of the opt-out is no longer permitted. Such litigation must continue in the national court. The opt-out cannot be withdrawn even after such litigation has concluded. This is an important strategic consideration, as Verena will explain, and I'm now going to hand over to Verena to talk about this and other strategic issues, as well as the question of SPCs and the procedural aspects of opt-out. Verena.
Thank you, Paul. Regarding SPCs, the question is, what happens to SPCs when a patent is opted out, and what happens if the patent on which the SPC is based has lapsed? The answer is that opt-out automatically extends to an SPC that is based on an opted-out basic patent in force. Even if the European patent has already expired, the opt-out of the SPC or SPCs based on it is still achieved by opting out the expired patent. If an SPC has been assigned so that the owner of the SPC and the proprietor of the patent upon which it is based are no longer the same, the proprietor and the SPC owner must lodge the opt-out application together. Again, cooperation will be needed between these parties to ensure an opt-out in these circumstances. However, it should be noted that SPCs are not currently available based on unitary patents, although the European Commission is considering how this might be achieved. But even at such time that it becomes possible to obtain an SPC on a unitary patent, either as a unitary right or an adaptation of current national rights or both, it will not be possible for these to be opted out of the UPC, just as it is not possible to opt out a unitary patent. The next question is, who is responsible for the opt-out and what is the scope of an opt-out? If the granted patent or application is owned by two or more proprietors, all the proprietors must lodge the application jointly. The consequence of this is that joint owners must all agree that a European patent is to be opted out, or the application cannot be made. The application to opt out must also be made in respect of all of the contracting member states for which the European patent is designated. This means that if the ownership of one or more designations should have been assigned to a third party after grant, those third-party proprietors must also be party to the application to opt out. It does not matter whether the contracting member state in which the patent is designated has actually ratified the UPC agreement at the time of the opt-out. Those patents will be opted out automatically at such time as these countries ratify. However, European patent designations for countries that are not contracting member states are not affected by the opt-out. It should also be noted that divisionals of a parent patent must be opted out separately in their own right to the parent patent. In other words, divisional patent opt-out does not follow from parent patent opt-out. An application to opt-out must be made in the name of the proprietor of a granted patent or in the name of the applicant for a patent application. A proprietor of a European patent is taken to be the person registered or entitled to be registered as a proprietor in the National Register. If there should be no up-to-date record of the proprietor in the relevant National Register of a granted patent or in the EPO register in respect of applications, a declaration of proprietorship is necessary. As I say, the proprietor is the person registered or entitled to be registered as the proprietor in the National Register. Normally, this would not include an exclusive licensee. Consequently, an exclusive licensee who wants a say in the opt-out of the patent to which they have rights, particularly if they are the party that is likely to be enforcing it, should negotiate an obligation on the proprietor to obtain their agreement to opt out and withdrawal on the terms of the license. Let us now take a closer look at the opt-out procedure. In order to exercise the opt-out of a European patent or application from the exclusive competence of the UPC and of any SPC granted on the basis of it, an application must be lodged with the UPC registry. The application must contain the details of the patent and any SPC that is granted on the basis of it, or the details of the patent application in question. These details include the numbers and designated states of the patents. Additionally, the name of the proprietors or applicants for the patent and the SPC holders, if there are any SPCs, must be included, as well as their postal and electronic addresses. There is no fee payable for an opt-out or the withdrawal of an opt-out, and if all the above requirements are satisfied, the opt-out will be effective from the date that it is entered in the register. At the beginning of this webinar, Paul mentioned the important recent development about the provisional operation period for the UPC. This will start prior to the full opening of the court to hear cases. Instead, in addition to allowing certain steps to be taken in preparation for the court to enter fully into force, during this period it will be possible to record opt-outs of European patents in the UPC registry. It is thus possible to opt out patents before a revocation action can be lodged in respect of that patent in the UPC. So this is a way of avoiding the trap of being caught in the UPC that Paul also mentioned earlier. As we also said earlier, we currently expect the UPC to come into force in early to mid-2017. This will be on the first day of the fourth month after the 13th ratification of the UPC system. However, the provisional operation period begins the day after the 13th ratification. So this means it will begin approximately 3 to 4 months before the opening of the UPC, depending on the exact day of the 13th ratification. The provisional operation period therefore provides the opportunity for a proprietor to opt out a patent, placing it in the jurisdictions of the countries in which it is designated before a third party is able to lodge an action to have it revoked centrally in the UPC. Given that there is a right to opt out of the UPC, the question is whether proprietors of European patents should use it. This is, of course, a strategic question which requires careful consideration of the consequences of opt-out for all European patents in a portfolio. There are a number of issues to bear in mind. The most significant of these is as follows. A very important issue is the Europe-wide revocation risk on the one hand, and the possibility to be granted a pan-European injunction on the other hand. A successful revocation will have effect in all contracting member states that have ratified the UPC system. At the time the court comes into operation, this may be as little as 13 member states, which is the minimum necessary to ratify. However, as more countries ratify the UPC agreement, the scope of the effect of UPC decisions will become accordingly greater. Also, for infringement actions, including preliminary injunctions, enforcement decisions may only be effective in as few as 13 countries in the early operating life of the UPC. However, even given these limitations in the early stages of the UPC's operation, the scope of decisions under the UPC is extensive compared to the current system of national court decisions, which are limited to national territories. In particular, decisions will cover the significant commercial markets of Germany, France, and the UK from the outset, because the ratification of these countries is mandatory before the UPC can begin. Furthermore, in the months after the UPC comes into force, the scope of application of decisions can be expected to grow to include most, if not all, of the contracting member states as they ratify. As a consequence, the powerful enforcement opportunities in the UPC have to be balanced with the risk of simultaneous revocation in a large number of countries. Another important issue relates to fees and costs. A UPC action may in some cases be bifurcated between infringement and revocation, and despite a number of consolidation provisions, there will be circumstances in which patentees have to enforce the same patent in separate proceedings against different defendants. However, an action in the UPC, either to enforce a patent or to revoke one, prevents the need for parallel actions between the same parties in the national courts. Consequently, the potential cost of a UPC action must be weighed against not only the court fees that might be payable in several national courts, but also the cost of paying the legal teams running and managing the parallel national actions. For European patent families covering several commercially very significant countries, the benefits in time and cost of using the UPC may be obvious. For patent families protecting a small number of territories, the cost benefits alone may not be so clear. Market signals may also have to be evaluated when considering an opt-out. Some patentees may wish to adopt a safety-first approach in which they opt out their most commercially important patents and thus remove them from the risk of a pan-European revocation until the court has become established and more is known about the approach it will take to patent validity. However, such a strategy may need to be managed carefully in the future to ensure that it does not send the wrong signals to competitors about the proprietor's confidence and the strength of the patents being opted out. Another issue is the risk of losing the possibility of pan-European enforcement. Patentees should be wary of assuming that the downside of a potential pan-European revocation can simply be avoided by opting out a European patent early with the intention of withdrawing the opt-out when it becomes desirable to use the upside of pan-European enforcement. This is because, as Paul explained earlier, if a revocation action or non-infringement action is started in respect of an opted-out patent in a national court, that action must remain in the court, and a withdrawal of the opt-out is barred, whether the action has concluded or not. The pan-European enforcement power is lost for good, and the patentee will find that it is unable to enforce in the UPC when it really wants to. There are also other factors that should be considered, although they are unlikely to sway a decision on opt-out on their own. In some cases, there will be differences between UPC law and national law. For example, the boiler exemption is presently narrower in the UPC agreement than it is in many national laws. There are also uncertainty about the approach the new court will take to enforcement and revocation, and patentees will want to be involved in the UPC in order to shape how law and procedure develops in the court. I'm now going to hand back to Paul England in London.
Thank you very much, Verena, and thank you to our audience for listening to today's webinar. As the preparations for the UPC gather pace, there are more webinars to come in this series. The next webinar, Part 8, will deal with UPC proceedings in overview and court fees, and further webinars are going to address search and seizure, use of experts and witnesses, remedies, and more besides. If you'd like to see past webinars, articles and updates on the UPC, may I also refer you to our webpage, which is shown on this slide, for a number of items of information that you could find helpful. Please remember just to hang on the line for a moment for the pop-up menu, and thanks very much to those people who've sent in questions by email. I shall attempt to get back to you as soon as possible after this webinar to answer your questions. And apart from that, can I just say many thanks again and goodbye.